one could write volumes about international arbitration. People have written volumes about it. But my task today is, in the space of 50 minutes or so, to provide a summary, an overview of the basic principles and practices of international arbitration. It's intended mostly for those who don't have a lot of prior experience with learning about international arbitration, but it's also intended as a kind of refresher course for those who may spend time in the international arbitration practices of their firms or businesses or law schools. It's always good to go back to a familiar subject and, just by way of refresher, recall what its basic principles are as one thinks about specific issues. The roadmap of the topics that I'm going to cover in the next 50 minutes or so is on the current slide. You can see it there. We'll start with a definition of international arbitration, then look briefly at the objectives of international commercial arbitration. The focus of this introduction will be commercial arbitration, international commercial arbitration, as distinguished from investor-state arbitration and state-to-state arbitration. I'll touch on those two topics very briefly at the end of the introduction. You can see them at points F and G, but the focus of our discussion is going to be on international commercial arbitration. And in particular, I'm going to look at the legal framework for international commercial arbitration, look at international arbitration agreements, arbitral procedures, and arbitration awards. Before then, as I say, I close out with investment arbitration and state-to-state arbitration. I'd like to start with a basic definitional question. What is international arbitration? Arbitration, as we know from both domestic